Are you a real estate investor or self-managing landlord with one or more rental properties here in the US? In this video, we're going to talk about possible legislative changes in 2025. You will have a better understanding of what those possible changes are, how they could affect you, and how you can become part of the process to make positive change for you as a landlord and an investor. I'm Stacy Wilson. My husband David and I own Wilson Management Group, which is a residential property management company here in Central Florida. We've been in business since 1986 and we specialize in single-family rental homes. Let's get into the rest of this video.
So yeah, I mean, this is just egregious bureaucratic overreach. And I will never forget a year ago, I believe this was at Southern States. I believe there was a presentation about this, and they had two people representing the EPA come and speak. And listening to them, I could have punched my head through the wall, because they sat up on the stage and talked about the opportunities for enforcement that they had been able to find with lots of research. And what that means is we found people we could find and we're happy about it. It blew my mind. It really did. So me being mad about this wants to understand, how does stuff like this happen? And so, of course, I went down the rabbit hole about how stuff like this can happen. Has anybody ever heard of the Chevron doctrine? Well, if not, I'll tell you about it. The Chevron doctrine stems from the Supreme Court's 1984 decision of Chevron versus Natural Resources Defense Council. The decision basically stated that if a federal legislation is ambiguous or leaves an administrative gap, the courts must defer to the regulatory agency's interpretation if the interpretation is reasonable. Notably, Chevron requires the courts to defer to an agency's reasonable interpretation of the statute, even if a court, left to its own devices, would interpret it differently. That is assigning a tremendous amount of power to an unelected bureaucratic agency. And the interpretation is reasonable. What does that even mean? Reasonable is probably going to mean different things to just about everybody. So there is a lot of room for overreach, mission creep. You've probably heard that term. A lot of room for mission creep there. So why did the Supreme Court abolish the Chevron doctrine 40 years after creating it? The court majority concluded that this type of judicial deference is inconsistent with another statute, which states that a reviewing court shall decide all relevant questions of law. In layman's terms, that means it is the court's responsibility to define what reasonable is, not an unelected bureaucratic agency. Makes sense to me. In his opinion, Chief Justice Roberts also described how the Chevron doctrine had proved to be unworkable and unpredictable. I would say that's a resounding yes when you consider what has happened with the EPA. In my personal opinion, the court overruled the Chevron doctrine because over time the Supreme Court of the United States concluded that federal agencies had expanded their regulatory powers well beyond those delegated by Congress through accretion of reasonable interpretations of the statutes that they administer. And accretion means just expansion. They say, oh, well, this would be good and this would be even better, so we'll do that. In short, these regulatory bureaucratic agencies that were tasked with enforcing legislation that was passed by Congress were also given the extreme latitude to decide the scope of their enforcement powers and what fell under their purview for enforcement and/or regulation. That seems like a recipe for disaster. So I'm glad that the Chevron doctrine got overturned. There's some source material if you want. I'll be happy to send it to you. But that's probably the one that pisses me off more than anything else. That was the end of the issues that we focused on Day of the Hill up in Washington, D.C. But we have the state version of this endeavor coming up in Tallahassee. And I reached out to Tyler Craddock to confirm what was going to be on the agenda, and he told me that the final agenda is still being decided on. But there are a couple of priorities that they are looking at. The big one that I think would be massively beneficial for all of this is being pushed by Harry Heist, and that is electronic service of legal notices. This would be revolutionary for us. Right now, as you know, if you serve a 3-day notice or you serve a 7-day notice of noncompliance or a notice of lease termination, those have to be served in person and if the person's not there to receive it, they have to be posted on the door. Imagine if we could dispense with all of that and send it by email. That would be so fantastic. So that's something that Harry is pushing for. I will back him 100% on that. I hope it passes. Another concern is source of income protections. Currently on the state level, source of income is not protected under statute. And some of you may recall a couple of years ago, Florida passed House Bill 1417, which was called the preemption bill. And what caused this was lots of local municipalities on a county level or even on a city level were enacting their own legislation that superseded the state statutes in the Landlord-Tenant Act. And so it created a tremendous amount of inconsistency throughout the state from an enforcement perspective. And so the Florida legislature got together and crafted House Bill 1417, which was called the preemption bill. And it basically said that any legislation in the Landlord-Tenant Act preempts to the state level. So you cannot have anything more stringent than what is currently in statute on the state level. Now, the source of income protection is covered under that. But the concern is there are some tenant advocacy groups who are working to get source of income protections passed under the Fair Housing Act, which would sort of be an end run around the Landlord-Tenant Act. And the result would make participation in Section 8 housing voucher program mandatory for everyone. And you can imagine, with all of the inconsistencies across the Section 8 platform that there already are, mandatory participation, in my opinion, would be fundamentally unworkable, and it would create just bureaucratic logjam, in my opinion, trying to implement it. So while that is not an actual bill that has been produced yet, it's something that they are monitoring and they want to prevent from happening. So again, this is sort of a proactive advocacy issue that we want to talk to our legislators in Tallahassee to say, please do not do this. And hopefully that we will be successful. I'll have more to report after Day on the Hill. Everybody, I implore you, if you want to get involved and if you want to help control the way you work your business and manage properties, get involved at least on the state level and attend Day on the Hill and engage with your local representatives. Go to their local offices, set up meetings with them, get to know them, because I promise you, it will pay massive, massive dividends. You're your first responder when it comes to how you implement your business, and so you have to look out for number one. And this is a great way to do that. So in conclusion, advocacy, participation of NARPM, in NARPM, contribute to the NARPM PAC. I won't ask who's doing that, but the NARPM Political Action Committee is on a national level, and then there's also the NARPM Advocacy Fund. And this enables our lobbyists, Troy Garrett and Tyler Craddock up in Washington, D.C., to meet with the legislators on the federal level, and they also come down and participate with us on the state level at Day on the Hill in Tallahassee. Contributing to these fundraising events lets them do their jobs better and gives them more support, and it gives them more ways to engage and advocate on our behalf. So I encourage you, if you're not already doing it, start contributing to a NARPM PAC and a NARPM Advocacy Fund. I was reminded of a quote while I was up in D.C. last week when we were having all of these discussions that seemed apropos for what we're talking about. And it was by Sam Adams. And he said, "It does not take a majority to prevail, but rather an irate, tireless minority keen on setting brush fires of freedom in the minds of men." I think that sort of defines what advocacy is for all of us. So I want to encourage you to, start setting brush fires, not in a literal sense, but, in a figurative sense.